in fact live right now.
Hi, everyone. Thank you for joining us on another episode of Joe Knows. Today, I have a good friend of mine, Scott Robbins, with me. And Scott is also an estate planning attorney. And Scott, why don't you introduce yourself?
Good morning, everybody. My name is Scott Robbins. I'm an attorney practicing in estates as well as elder law and some other complex estate matters.
Yeah, so um, I went to law school with Scott, and I practice estate planning. Scott is the guy that I use for more advanced planning than the stuff that I do. And so while I handle 99% of most matters that come to me, once it starts going to court or it starts getting tricky or more complicated, I'm sending you over to Scott. If somebody passes away, I'm sending you over to Scott to handle those issues. So now you said estate planning and elder law. Why don't you explain that to people who might not be privy to that?
Sure. Well, when we think of estate planning, it's what I think of as the foundational plan to making sure that somebody's protected in the event they become incapacitated or they pass away, so that the right person can make decisions, somebody can manage financial matters, somebody can make health related decisions, or if they pass away, who's going to be in charge of managing money, making distributions, handling burial funeral arrangements. And then the elder law piece takes it another step. It addresses specifically how we're going to maximize an individual's level of care, ensure that they remain in the least institutionalized, least restrictive setting, and stretch their money out as far as possible so that it can have the least impact to themselves as well as the rest of the family.
And then why don't you explain, which law firm that you're at and how people can get a hold of you?
So I work with Baron Rosenberg, Mayoris and Mayoris. We're located in Troy, Michigan. Best way to get a hold of us is to contact us by telephone. Provide the phone number.
Yeah.
It's 248 641 7070. I can also be reached by email, which is S as in Scott, and then my last name, Robbins, Robbins, at brmmlaw.com.
Awesome. And then um, what other aspects of estate planning do you think people, I mean, obviously people are not too aware or educated, through our schooling about, what a trust is or wills or powers of attorney, stuff like that. Um, what do you see people lacking in their education and that they might need to know just generally?
I think the biggest misconception that people have, and there are several, but the biggest one is that you don't need to have assets in order to need an estate plan. A lot of people think that you have to have money in order to need a trust or a will or powers of attorney. And anybody, regardless of their financial situation, can become sick. And there isn't any individual for an adult over age 18 who would have somebody automatically authorized to make decisions for them or handle their affairs without going to court. So the moment that an individual reaches age 18, they should put some sort of basic document in place so that a parent, a friend, a significant other, somebody that they trust would be able to step in and make decisions without needing to go to court.
Yeah, I think that's the number one thing that I see too is um for me is that people always think of estate planning for when they pass away,
Mhm.
but they rarely think about taking care of themselves if they're not able to when they're still alive.
Yeah. I mean, most people think about it as something that you need when you get old. It's really something that you need if you plan to be old. And everybody has a window of opportunity. It's what I always explain to my clients, that there's some window where they can prepare documents and they can get everything created, but we don't know when our window is going to close. And the documents have to be prepared ahead of that window closing. And so if you put it off for extended periods of time, there's a greater and greater risk that some event could occur where you now don't have the documents that you need. And again, our only resort at that point would be to pursue court assistance.
Yeah, so when do you see the time that or like what events that happen in someone's life are the triggers of like when they should come and talk to somebody about estate planning?
I think it could be a lot of different things. For, I would say, most young adults, having children is going to be the trigger that prompts them to reach out, because their primary concern is who would look after my children if something happened to me. It can also be some sort of tragic or health event for other people. It could be the loss of a parent or other family member, a friend. It could be some sort of illness where a family member suffers a stroke or is in the hospital. And at that point, they start encountering barriers where the person who thought that they were going to be the decision maker is, reaching blocks and isn't able to handle decisions appropriately. And so one thing or another will typically prompt somebody. I would say it's usually rare that somebody just says, I think it's an important set of documents that I
Yeah.
should get. And, there isn't anything that really pushes them or serves as that eye opener for them to get it.
Right. And if you guys have any questions, feel free to ask, and we'll try to answer them if we're able to while we're live. And if not, we can answer them later on at a different time. Everybody hears about probate court. Why don't you kind of give, the rundown generally on probate court and the drawbacks of having to go through that
Sure.
process?
So the probate court is there to assist us where needed. So it is a valuable tool, and they do provide help. I think in most instances it's something that's worth avoiding if it can be avoided, but that's not the case in all instances. And so when it is needed, it's something that we embrace, and we go through the process as needed. Um, if there's ever a decision or a matter that can't be resolved because the authority doesn't exist, in most cases that's the absence of a document that would enable somebody to make decisions. We have to go to the court to get the authority, which could be incapacity related. If an individual doesn't have the ability to make and communicate informed decisions, if they lack the ability to manage their property and business affairs, if somebody who looks to an individual for support or money is not able to receive that support, that's when the court would get involved and put somebody in a position to handle those decisions for the individual. The court would also get involved if an individual passes away without having some sort of connection between their assets and somebody else. There isn't a mechanism already in place to transfer a home, a bank account, a car, any other asset, investments, retirement, to a spouse, a child, a friend, a charity. And the court is then required to appoint somebody as a decision maker, and that person who's the decision maker is following a set of instructions to make transfers and to pull those assets out of the deceased individual's name. The process that they follow can be one of many pathways, and that's going to depend on the specific matter itself. It's also going to depend on whether somebody had any documents, some documents, to what extent the documents, were thorough and addressed everything. And, going through that process is really going to depend on a case by case basis as far as what we would actually do.
What does it look like for somebody that's going through probate court for a loved one, like in terms of timeline, inconvenience, for lack of a better word, on the people or the parties that are going to probate court, and getting the matters resolved?
It's such a wide range in terms of time. A lot of it's going to depend on the courts, because every court is going to have a different line essentially for people waiting to get in front of either a judge or a probate register so that their paperwork can be processed or their case can be heard. So a lot of it will depend on where we're actually handling the matter. Depending on the matter itself, sometimes we can get things resolved or addressed in a single hearing or a single submission. Other things will require this constant back and forth between the courts and ourselves and the clients. And so on the shortest of ends, I would say, maybe a couple weeks. On the longest of ends, it would be, months or even years, depending on the nature of, what's going on, which tends to lead to why people try and avoid it. Time being one of the biggest things. Another thing is publicity and cost, which is associated with probate. But I would add that while probate gets a bad rap for a lot of things, the costs associated with probate are often misconceived. There's rumors floating around out there that probate would take a half or a third of the assets going through that probate process, and that's far from the truth. There are costs, and there's inventory fees and those kinds of things, but they don't take half or a third or anything like that.
Yeah, I haven't heard that part of it, but I do know, I do tell my clients the same thing that you just said, where it's going to be more costly to go to probate court than to do your documents ahead of time. You're not going to have as much control over who's going to be taking care of you and what their authority is to be able to take care of you, and protection of your assets and all that stuff. But I have not heard the third to a half of the assets for probate court. That's crazy.
There's various numbers floating around out there. I think the biggest thing that's associated with the probate court, the primary reason why you'd want to avoid it is the lack of control. Because if an individual doesn't take matters into their own hands and appoint people that they choose and that they trust, you're looking to the court to select an individual. And in almost every instance, the court or the judge isn't going to know the family members and the friends that you do. And they're not going to know the people that you would select and that you would trust. And being that they're complete strangers, they're going to give them a very short leash to make discretionary calls and to be able to manage assets freely without restriction. And there's history with some older cases in some of the courts where they've instituted requirements that regardless of the situation, there's certain more restrictive procedures that have to be put in place in order to protect the individual for whom protection is needed. And so you can avoid those things and avoid potential situations where the court would give you a no answer by implementing documents on your own and just taking matters into your own hands.
And so what are some of the reasons why we would want, I mean, obviously, if choosing the person that you trust, to handle your affairs is always great, but what are some other reasons that people might not know about of why they would want to do that?
To do what?
To select someone on their own, right? Like to get the paperwork done ahead of time,
Yeah.
selecting the person that they trust and giving them more authority. What are some of the benefits that come along with that people don't really know about?
Primarily, it's a privatization of their affairs. Anything that goes through the court process is a court forum, and so people can appear at court hearings. They can participate in them. They can get paperwork that's been filed with the courts, and so they can see what's going on, and it just makes a lot more what would otherwise be private information available to others. The authority that we can include within the documents goes really a long way when it comes to a lot of the elder law strategies that we do, but it does extend just to general day-to-day management of a person's financial affairs, as well as being able to manage real estate, being able to make decisions with regards to end of life. These are all things that the documents that we create can specifically give somebody authority, and it can spell out exactly what your wishes are. Again, when the court gets involved, they're going to be cautious in granting this authority and granting the discretion, because some of these decisions can't be undone. And so before the court will allow somebody to make one of those decisions, they want the matter actually brought in front of the judge so that the judge can participate in the decision, which for most people isn't something that they would want a stranger to participate with. So we can expand the authority that would otherwise be provided, and in a lot of instances, keep any sort of matter from ever requiring somebody else's participation, or somebody serving as a gatekeeper to those decisions.
And then, so like in probate court, are there any stories that you have of like something that has happened that you can talk about, maybe that put people on notice of like this is something that could happen that could be avoided, type of thing?
Um, Most of what goes in front of the probate court could be avoided. There's a lot of instances where, again, with the lack of documents, somebody needs to make decisions, and I've had judges say that these decisions, the requests that are coming in front of them, the need to appoint people, they wouldn't exist. These matters and the cases wouldn't exist. They wouldn't fill up the file room within the probate courts if people just took the time to put the documents in place. Um, Off the top of my head,
Yeah.
I
I've-
can't think of
I have a crazy one.
okay.
So I recently met a realtor, and she had clients, and they were selling their house, and the husband was on the title of the house, but the wife was not. And they signed the purchase agreement. It was like maybe a week or so before the closing date of the house for them to sell. And the husband, something happened and he fell into a coma. They can't sell the property anymore.
Right.
Uh, so they had to go to probate court to get permission to be able to sell the house, whatnot. 2 weeks later, the husband gets out of the coma. So they had him signing documents once he became, cleared by a couple of physicians that he was able to make the decisions. But you're selling a house and some random freak accident happens, and then your family gets stuck in the situation where they're not able to do anything at that
Right.
point. So that's something that could be avoided with having your documents in place ahead of time, giving authority to other people to be able to do those things for you, uh, so that you don't miss out on an opportunity like that.
It's something like that could have been avoided with the preparation of a general durable power of attorney, where one spouse grants to their other spouse the authority to do that. Obviously, the coma is a perfect example of where that could be used, but it could also be used just for pure convenience. If you think about a couple selling property and somebody's on a business trip, if
Right.
they're out of town, the other spouse could actually handle that transaction on their own. It obviously requires a little bit more paperwork to do that on somebody's behalf, but it is possible. It's also something that I know a lot of our clients use for preparation of tax returns when it comes to reviewing them with tax preparers and getting everything signed. Sometimes it's difficult, just to coordinate those meetings with the CPAs or tax preparers, and so we'll have clients sign for themselves and then using that power of attorney sign for their spouse, and so it can actually assist in a lot of different settings.
So we have a question from a Facebook user saying, "Have you ever worked a case together?" We work multiple cases together, but we whenever I have some questions on some more complicated estate planning tools, I always ask Scott for advice on what strategies to use in those particular cases. Once it gets out of my realm, so if somebody passes away, it's going to probate court, whatever, I don't want to deal with those. So I send them over to Scott. I know he can handle them. I trust him taking care of those cases. It's an easy handoff for me to just say, call Scott. I know you're being taken care of. I know he's going to do a good job. I know he's going to communicate with you, and take care of it. Uh, it's difficult to find people, and so he is my person that I communicate with for estate planning. So um, we don't necessarily work on the same stuff at the same time, but we do coordinate and work together on those cases.
Yeah, I was going to say I don't know that we've ever been retained as the attorney on the same matter, but we've definitely communicated about various issues and talked about what the strategy or what the final plan was going to be, and the essentially reached a resolution working together, but there hasn't actually been a retainer where somebody hired both of us as their attorney.
Yeah.
Primarily, I would say the reason for that would just be cost efficiency. If
Oh,
you know
yes.
if
Yeah.
if there's a need for an attorney, obviously there's going to be some sort of cost involved, but you know why pay for two when you can just hire one of us.
Yeah. So we have another question. It says, what happens to your assets if you don't have any documents in place and you pass away?
So if you don't have any documents in place and you pass away, the easy answer would be it goes to probate, but my actual answer is going to be it depends, and that depends on how the assets are actually titled. So if you've got a house and you have a child that is also on the deed, or you have a spouse that you own that house jointly with, it doesn't become a probate asset just because you've passed away with no documents.
Well, clarify that, because I've had issues with that. So even if you have somebody on the title, it has to be written such that if one of you passes away, the other person will get the whole house.
Correct.
Yeah, there are other ways of owning houses where each person owns their share and they can devise their share to their family or friends or whoever they want. But uh, the reason that I said to clarify it is because I've had multiple people come to me and they try to band-aid fix without talking to an attorney
Right.
by adding somebody onto title,
Yeah,
but they're not doing it the right way.
I would never recommend just adding somebody onto a piece of property without consulting with an attorney first, because there are a handful of problems you can encounter. But to answer the question, and I don't know if I said the word jointly yet, or I would have, that word actually has special legal meaning. And so if people own property jointly, or there's a bank account that's co-owned, those typically are going to have a right of survivorship where the surviving owner is going to continue to own that asset individually. That could also be the case when you have a beneficiary designation. But if there's an asset that is individually in a person's name, there is no joint owner, there is no beneficiary designation, it ends up needing to go through probate court because it's in a way stuck in that deceased person's name. We have to be appointed. The court has to select somebody to serve as the representative for that deceased individual to take those assets out of the name of the deceased individual, figure out who's entitled to it, and transfer it to those individuals. So when you've got no assets, usually there's a fair probability that something will require the probate court, but everything doesn't automatically go through the probate court. You always have to start with, how are the assets titled? How is everything designated with beneficiaries? And from there, you can figure out what needs to go through a court procedure or some other administrative process to find its ultimate destination.
Yeah, that's a good overview for people that don't know. Because that's another thing too, is like, okay, so what do you recommend for people that want to just name their children as beneficiaries without having an estate plan in place?
I probably have 100 questions that I'd want to ask you before
Yeah.
I give you a straight answer. It's really going to depend on the nuances. How old are your kids? How many kids are there? What are the value of these assets? What type of things are going on with your kids? Are they healthy? Are they married? Are they going through a divorce? Are they dealing with drug or alcohol problems? Are they being sued? Are they in a high risk job? There's just so many questions that I would have to ask and get answers for, so that I understand the complete picture. It may be something where we utilize beneficiary designations and a special type of deed. Again, I typically almost never will recommend just adding a child blankly onto a deed. But there are special types of deeds where you can effectuate a transfer on the death of the individual. Sometimes we'll do those, but a lot of it's really going to depend on the actual circumstances of that individual's story and what their picture looks like, because it's going to vary person to person. And if somebody takes one thing away from this this podcast, would be, don't assume that what your friend or other family member did is right for you, because everyone's story is different, and one little nuance, one tiny change in a variable can make a world of difference in one person's story to the other, and how one would result versus the other. And so it's really important to have somebody who's knowledgeable and skilled in the area to look at your circumstances and make a recommendation for you.
Right. Especially when, I don't know if you get this a lot, but I typically get people calling me and they say, how much does it cost for a will? And without giving me any information. And I'm like, wait, hold on, let's take a step back. Like, I have to know some things before we go and jump into what the costs are going to be, what documents you actually need, because everybody calls it a will. I mean, I even have clients that tell me, I need to update my will. And I'm like asking them questions. And then I realize they actually have a trust. and other documents in place already.
Right.
They don't know that they already have these things in place that they need to update. And so it gets more complicated as to what they need, because they don't know the terminology. What they're trying to say is, I need to update my estate plan, or I need an estate plan. And how can you help me with that? And then I start asking them questions. And, for whatever reason, people get into the situation, but they have assets not only just maybe titled in their name or maybe a spouse's name, but then they have it titled in just a third party's name, like a friend or a family, a cousin. So I asked the client, he wanted to do an estate plan, and I asked him, do you have a house? He said, yeah. I said, do you have it under your name, your wife's name, or both? He said it's under his cousin's name. I'm like, that's not your house. That's your cousin's house legally. We would have to take care of documentation for, what happens if your cousin passes away or becomes incapacitated. Who's going to be able to sell that house? Who's going to get the proceeds of that? There's certain things that people do to acquire assets because the everybody looks positively on certain situations, right? Like, if I get a business, I can make money. If I get a house, this is what I'm looking for. I can live there. I can have an asset. They will do whatever it takes to get that asset, but they don't realize what it takes to protect it for them and their family.
Yeah. And a lot of people just aren't familiar with some of the pitfalls to the strategies that they know of to try and protect those assets. So acquiring a home and transferring it into a cousin's name, or adding a child onto a bank account, or some of the other strategies, in some circumstances, they may work. And I think you can always find a success story where that happened to work, but
Right.
there are so many pitfalls and so many interests that have to be balanced, and it's even more compounded when you start to deal with the elder law issues, because if somebody's looking to acquire some sort of public assistance to help pay for the care that they need, you run into issues when you've added people onto other assets, or you've made transfers to assets to include other family members, or even putting them into trust can sometimes be problematic. So it's really something that you should talk to somebody that deals in that area, so that they can weigh all the pros and cons, they can balance all the interests, and try and figure out what the most appropriate plan would be.
Right. And that's part of the reason that I communicate with Scott on a lot of my cases, is because, as him being an elder law attorney, there are some things that I'm not as familiar with, where I'm like, okay, this issue triggers something, and I need to talk to Scott about it, just to make sure that what we're doing is not going to affect them in the future if they were to need the public assistance. Or, I'm good at issue spotting, and I can say, like, okay, I've come across this before. I know how to handle it. We're fine in this situation, versus, I haven't come across this before. I know that there might be an issue. I just need to talk to Scott about it to make sure that we're good, and then we can take care of the issue the proper way.
Yeah.
Because I always call it like Band-Aid resolutions. You talk to your friends and family. They might be in a different area. They're not even an attorney, right? Like, maybe they're a realtor, or a home and auto insurance salesman, or a mortgage broker, or whatever. And they're like, yeah, we can add somebody onto your title, or whatever. Or I've somebody else did this thing, or whatever. And just like Scott said, there might be one small issue that you're missing.
That's different in your situation.
Yeah, that you're gonna complicate things unnecessarily by trying to take care of it, because you're only getting the options that person knows, right? Like, there might be 10 different options, but you only know one or two, and you're picking the best out of the one or two options that are available to you, not knowing that there are better options out there that you could use.
I would say that almost every single meeting that I have, at least once, I hear, well, in blank's situation, this is what happened, and this is what they did. And you could fill in the blank with anybody. It could be a relative, it could be a friend, it could be a stranger, it could be somebody that lives down the street that they hardly know. Everybody has some experience, or somebody that they've spoken with who will give them a story of a similar situation. It may be almost exact, and the solution that they have is only what that person or what that story led to. And sometimes it is the solution. I would say most times it's probably not. But it happens almost every meeting that I'm a part of, where somebody will say, in so and so situation, or when my mom or dad or grandpa died, we just did this, and I can't always explain why you did that, whether that was right or wrong, even if there's no repercussions that forced that to be undone. But that's most cases not the way to go about it, or the way that I would recommend somebody to go about it, because you're creating risks and liabilities. And the last thing I want to do is help somebody get to a quick resolution and then get a phone call a month or a year later where they're upset because now somebody tells them that they owe a bunch of money because they didn't go about discharging other obligations in the right way.
Right. And that's the same thing too, is like, I have a lot of people that are intelligent people, and they say, can I just write something down on a piece of paper? And so by me asking one next question, they end up realizing that's probably not going to happen. Right.
Right.
Like somebody says, when I die, I want everything to go to my siblings. And then I ask them, like, well, what happens if your siblings pass away before you?
Right.
And then they're like, well, I didn't think about that. Like, that's just the tip of the iceberg of asking you the questions of like, what happens if this thing happens, and you don't have an answer for it. So it's always good to, speak with an attorney to figure out all of your options. And I'm sure Scott does the same thing. I like educating my clients. They come to me, I'm like, okay, here's 2 or 3 different options that you have. One is the basic Band-Aid solution, basic level of what you can get away with to protect the one issue that you're asking about. I don't recommend that, or maybe it might work in your situation, but here's 1 or 2 other options that are complete plans that will take care of you, not only if you pass away, that, taking care of your children, taking care of your assets, but also if you're still alive, who's going to take care of you, who's going to make those decisions for you and protect your kids for you in that situation as well, where, you didn't necessarily think about that at the time when you come into the office.
There's another area of planning that I haven't even mentioned, or we haven't addressed yet, that actually is to minimize fighting. We talked about what happens if you become incapacitated, who makes decisions? What happens if you die? Where do your assets go? What happens if you're not able to express what you want in any of those circumstances, and there's a difference of opinion as to what you would have wanted? And so when you take matters into your own hands, there's oftentimes a lot of details that are omitted, which would change the end result to an administration or some sort of decision to be made. And the difference of opinion can actually create humongous fights, even with the closest of friends and family members. And so by creating a document that's going to address all these variables, even the things that are almost impossible to occur, things that are so unlikely, to ever occur, we are eliminating instances where it would otherwise turn into a big fight. And the other half of the firm, that I'm with, deals with litigation and deals with families that can't get along, or situations where there's challenges to a person's way of administering an estate or a trust or anything like that. And so my goal is to try and avoid those conflicts and provide simplicity and avoid ambiguity when creating those documents.
But my kids don't fight.
I hear that all the time. Everybody gets along, and there's nothing like the death of a family member to trigger some long-standing resentment between family members, or to just be the trigger that starts some sort of family war. And so even when people tell me that their kids get along as good as any other, I say that's great, and let's hope that continues to be the case. But let's just be proactive in case something ever goes sideways, or even to prevent something from turning into a much bigger issue. Because when you spell things out in detail, a little disagreement can be resolved, and it doesn't become something bigger when you have a comprehensive set of documents in place.
Yeah, like who gets the red cup? That's a big thing in my family. My kids fight over which color plate and cup they get. for dinner.
I
So,
would say green.
yeah.
Green is what's fought over in my house. But yeah, same thing. And 100%. I mean, there's the strangest things that you would never think would create fights. Obviously money is a big one, but the chair, the old torn up chair that dad used to sit in somehow becomes the subject of everybody's desire, and figuring out where it goes, and again just spiraling into other issues.
Yep.
It's not an unheard of thing. And so trying to avoid those conflicts and avoid ambiguity is a major goal. So
Yeah.
we do that.
And it's always like a stressful time dealing with somebody's passing, a loved one. Now you're getting all these tedious tasks to have to do at that time that you don't even want to deal with those tedious tasks in your everyday life without having to go through that stress. It adds upon it.
Right.
So yeah, so that's good. I think we have a good overview of what you do and how you can help people and how we work together on estate planning matters and probate. Why don't you talk about some stuff that you like to do in your free time?
Well, for the longest time, as long as I can remember, I've always been into bowling. So, COVID set that back a little bit, but I've actually gotten back into it this year. So I've rejoined a league, and I'm enjoying it. Although my scores have not been as high as I would have hoped. I do a lot of housework. I take a lot of pride in my lawn, and so a lot of weeding, a lot of fertilizing, mowing, edging, all that stuff. I'm also one for home improvement projects. So anytime we need to put some fresh paint in the house, or fix one of the toys that either of my boys has broken, I'm always up for the challenge. And so I seem to have a pretty good track record with that. And I would say that takes up the majority of my time.
What's your favorite home improvement project that you've worked on?
So we're actually in the process of updating this front room in our house because it was a dining room that we never used. We're converting it into like an office and den, and we've hired out for a lot of the big projects. But I actually wanted to do the recessed lighting as well as some other lighting, like wall lighting. And I was insistent that we put a TV in this room, and so I wanted to just get all the foundational bits set up on my own. And when we actually had a contractor out, he asked who was going to do it, and I said, "You're looking at him," and I could see from his responsive look that he didn't have a lot of confidence in my abilities. And so I took that as a challenge that I had to do not as good of a job, but I do a better job than a professional, electrician, drywaller. And no disrespect if any of you are out there, you probably know a lot more than me. What I did was very basic, and it took me probably 10 times longer than it would have taken anybody else. But this room it's looking flawless. You cannot see where the patches are. You cannot see. I mean, everything is clean. It's neat. And I spent a ton of time on it, but I'm actually very proud of it. And my wife will tell you that.
We're going to have to see pictures. Trip, we're going to send you over there to take pictures.
I will. Yeah. You're more than welcome. I'm very proud of my work. But again,
if you need an electrician, if you need recessed lights, Scott's the guy.
I don't know. Again, we're most, drywall people could probably patch something in a single pass. It took me, 6 of going, sanding and mudding some more, but eventually it's just indistinguishable. And it's
nice.
It's a very prideful room for me.
What about, we were talking about traveling earlier. What's your favorite place that you've been to?
Africa, hands down, without even not even thinking about it. I would love to go back to Africa. My wife and I actually decided to go to Africa for our honeymoon.
Okay.
Because Hawaii is a definite consideration. Greece, I think at the time, was super popular. I think it still is.
Yep.
And we looked into those and they looked amazing. And then we also considered Africa as sort of this wild card. And looking at all of them, we thought that Africa would be the best choice because it's one of the most difficult to get to, especially if we have children. The place that we went to doesn't allow kids. And we just figured that if we didn't go then, it would have been a long time before we would have gone. And I would recommend it to anybody. We went to South Africa and did a safari for I think 4 days. It was absolutely amazing. I mean, seeing animals that aren't at the zoo, you're in this open Jeep. There's lions, 12, 15 lions that are just right there, 20 feet away from you. And, I mean, we saw everything. We saw elephants, we saw giraffes, zebras, rhinos. It was so cool. I
That's
cannot
awesome.
recommend that enough. Everybody should
Okay.
do that.
All right. I'm gonna have to talk to you after.
Yeah.
We're planning our next trip. I don't know if Dina would be down for the animals that close though. So
It's cool.
We'll see. I have to talk to her.
And you
about
feel
it.
safe because the trackers and all the other people, they've got some serious weaponry that is ready to go if
Okay,
anything
sweet.
goes sideways.
Yeah.
But most of the animals, because they've been doing the safaris long enough, they actually become accustomed to the cars and the people. And really, the only
Okay.
rule that they tell you is stay seated, because they're used to people sitting in the cars.
Yeah.
If you stand up to get a better view, that might be a little bit strange to them, and
Okay.
that's where things can start to get a little hairy.
So basically, get your estate plan in place before you go to Africa.
Yeah,
that's
of
what
course.
Scott's saying.
That's a good segue
Yeah.
to round it out. Yeah, definitely. Yeah, I mean, anytime people travel, a lot of people will come up to me and say, or call me and say, I'm planning on taking this trip. What if something happens to me? And
Yeah.
obviously, sometimes
what-
we can scramble to get things in place. But you never know what's going to come up or what's going to be needed. So the time to plan is now.
Okay, let me ask you this now, because you brought it up, and I just recently had somebody. So I went to Europe recently, and a potential client contacted me very close to when I was leaving, and they were actually going to Europe also, and that was what triggered them to get their estate plan.
Right.
And I was able to get it done before I left. But what do you say the timeline is of when somebody contacts you and gets the information to you, for how long it takes to draft the documents and get them signed, so people understand, like, you can't call me on a
Right.
Monday
Yeah.
and expect to sign
And
it
have
on
everything
Thursday.
done. Yeah. I'd say 4 to 6 weeks, but that's also fairly fluid, because a lot of it's going to depend on how many cases we've got right now. We are very busy, and so I would say it's probably maybe 5 to 7 right now.
Okay.
A lot of it's going to depend on how complex the documents are, what you actually need. Have I gotten all the information that I need so that I can put everything together?
Right.
And so, I mean, there is going to be a lot of back and forth. Generally, 4 to 6 weeks is my go-to answer, but it can be shorter or longer. There are some emergent situations. Going back to any interesting stories. I actually had somebody call me telling me that they were going to die that night and that they needed estate planning documents. And I met with them, and I didn't get it prepared that night. They also did not pass that night. They actually passed about 48 hours after that phone call. And we still weren't able to get everything done. But because I was thorough with my notes, and I gathered all the information that they wanted to have put in the documents, we were actually able to petition the court, which again, it required court. So the full objective wasn't achieved, but we were able to petition the court to get my notes admitted as their will. And it provided all the direction that was necessary in order to administer the estate. And it's a very unconventional process. I wouldn't recommend that for anybody, but there are, saving procedures and things that we can do regardless of the situation. So it's never too late. It's also never too early though. So if you don't have anything in place, get something in place.
Yeah, that's my thing too, is like, do it now. It's like people like, well, I'm about to buy a house. I'm like, get the documents done, and then when you buy the house, we'll add it to the documents. Like,
Yeah.
you know what I'm saying? Like, don't make the decision off of what you think. Talk to somebody, one of us, and then we will let you know what you should do, and then you can make the decision off of knowing instead of thinking that you can't or should wait. That's it.
Right.
Yeah.
Yeah. Usually the recommendation is not going to be to wait.
Right. Oh yeah. I usually tell people, I'm like, get X, Y, and Z now, and then we know that this thing is going to happen in the near future. We'll accommodate for that, and when that thing happens, we'll add it into the plan.
Yeah, as somebody amasses assets or things get more complex with their life, it only makes creating the plan more complex. If you create it ahead of time and it's something that's in place, as time goes on, as you buy or sell things, as life gets more complex, you can update that plan and incorporate those things. And it's a small task with each change rather than this monumental responsibility, at the time you finally decide to do it.
Right. And then building on it and making the changes becomes easier because most of your stuff is already prepared to be able to add or make the changes later on. And usually the changes are not that significant. Or if you have a new asset or a new business or something like that, it's only one piece of the puzzle that needs to be worked on at that time.
Right. Yeah.
All right. So why don't you give people your contact information again?
Sure. My telephone number, best way to reach me is 248-641-7070. And then email, feel free to email me anytime, is srobbins, ROBBINS, at brmlaw.com.
Yeah. So thank you again, Scott, for joining me. And like we said, if for all of your estate planning matters, if you want to contact me, if it becomes more difficult or complicated, or somebody needs to go to probate court, I can identify that. I'll hand you off to Scott. He can address those issues for you, and you and your family can be covered with all of your estate planning needs at that time. Thank you, everyone, for joining us. My name is Joseph Dallow, and my phone number is 248-914-8146. And my email address is joe@dallowestateplanning.com. And Joe knows, so you don't have to.